Is your business protected against the threat of malicious litigation and frivolous lawsuits? Are you sinking company profits into marketing campaigns that do nothing to contribute to the growth of your business? Bottled Business Sense provides practical business perspectives that uniquely emphasize both legal and media marketing strategies to protect and ensure the longevity of your business. Now, whether you're trying to provide a startup business with some level of stability or an established business with foolproof asset and estate protection, or simply attempting to get a better return for your business marketing dollars, Bill Bernard and Rick Moscoso will expose potential pitfalls to ensure the security and growth of your business, free from unwanted expense and the threat of litigation. You'll learn how to implement marketing and protection tools equal to those used by today's most successful corporations. Let's join Bill and Rick for today's Bottled Business Sense show.
Good morning, everyone. Today is Tuesday here at 10 a.m. on the Bottled Business Sense show. Welcome. I'm Rick Moscoso, one of your co-hosts. We have Bill Bernard on the other side there, who's going to talk a little bit about California conditional offers of employment. But before we get into today's topic, I want to welcome Bill onto the show. How are you doing today, Bill?
I'm doing great, Rick. Thanks. Couple of preliminary notes here for our viewers. The Bottle Business Sense show now will be seen on the Bottle Business Sense show website. And it will also be seen on, or can be seen on WFBlegalconsulting.com, where you'll see a drop-down box for the Bottle Business Sense show. So on either of those two websites, WFBlegalconsulting.com and BottleBusinessSenseShow.com, you'll be able to go and watch the show, or if you want to do something in the background, just listen to it while you're playing it. We're no longer on Blog Talk Radio, and so you can watch the show on those two sites that I just mentioned. The reason I'm talking about the topic today, Rick, I know it was August, but I don't remember if it was August 2016 or 2017. We did a similar show, but the law has been updated on this topic, so I wanted to bring it to the attention of our viewers for that reason. And I think it's important to point out for employers and employees that 1 out of every 3 Californians, this may shock everybody, but 1 out of every 3 Californians has a criminal record. And because of that, they often apply for employment like anybody else. And it's common for employers to ask about a criminal history on a job application. That's always been the case. But as of January 1st, 2018, California's Ban the Box law came into effect. And the Ban the Box law has to do with the California Fair Employment Act, or FEHA, which is really the California Fair Housing and Employment Act, capital FEHA, FEHA. And FEHA makes it illegal for private and public employers with 5 or more employees to ask about a criminal history until the later stages of the application process. So in other words, previously on applications, you would check a box whether you had employment, a criminal history or not. That's no longer effective because the purpose of the new law, as of 1/1/18, is to encourage employers to assess an applicant's fitness for the job rather than categorically deny employment to those with a criminal past. Because there are certain, they want to promote, obviously, giving people who have paid their dues to society a second chance, and they want to make sure that you're not discriminating against an employee for any reason other than a criminal history that might be relevant to the particular job for which that person is applying. So because of that, the new law requires employees to remove the question commonly found on employment applications, quote, have you ever been convicted of a felony, unquote. Applicants can no longer be asked to check yes or no to this question. And in fact, employers cannot ask about look into or even consider a criminal history of an applicant until after the applicant has received a conditional offer of employment. So if the employer wants to hire the employee, at that time, once the employer makes that decision, then they can go ahead and investigate the criminal background of an applicant, but not before. And this is important because once an employer makes a conditional offer of employment, it can ask about conviction records. Now, we're going to get into this a little bit later in the show, but conviction records. So you must have been convicted. Other things do not come into play, and we'll get into those in a second, like I said. Some records, including arrest records that did not lead to a conviction, are off limits at any point in the hiring process, even after you receive the conditional offer of employment. So one, you must have received a conditional offer of employment. Then you can do a criminal background check, and you can only do the criminal background check with regard to convictions. So when an employer makes the conditional offer of employment, the employer must conduct or can conduct an individual assessment as to whether a conviction that the employer has found pursuant to the background check has a direct and adverse relationship with the specific job duties of the position. That means an employer must evaluate. An employer has the obligation to evaluate, one, the nature and severity of the offense; two, how long it's been since the applicant committed the offense and served his or her sentence; and three, the nature of the job the applicant is applying for. Let me give you an example. Suppose an applicant has been convicted related to a prescription drug abuse from 5 years ago, but has completed rehab and has been sober ever since. Depending on the circumstances, the conviction might be a reason to deny employment for a position at a pharmacy, for example, but not for a position at a call center. So the obligation is not only to wait until the particular conditional offer of employment has been made, but once it has been made and a background check is then done by the employer has to undergo these three methods to evaluate whether it's relevant to the particular job being offered. And in that regard, the employer must provide notice and an opportunity to respond to the employee. The employer must specify the conviction that was the basis for the decision denying employment, provide a copy of the conviction history report to the employee, and explain the applicant's right to respond with favorable evidence by a certain deadline. So the applicant must be given at least 5 business days to challenge the accuracy of the employer's conviction information. So the applicant might submit evidence of a completion of a drug rehab program or the applicant's efforts to make amends for the crime, so forth and so on. And if the employee, or the applicant, I should say, at that point, notifies the employer within 5 business days that he or she is taking steps to gather that evidence, the applicant must be then given an additional 5 business days to respond. So it's a little complicated, but not really. 5 business days they're given to challenge it once the employer provides the denial. Okay, I'm going to deny you employment. I did a criminal background check after I made you the conditional offer of employment. It's conditional based on the background check. I now have determined, pursuant to the criteria required by the statute, that this is relevant to the job position for which you're being offered. And because I think you shouldn't have that position, I'm now going to give you 5 days to respond, telling me why you should get the position. The employer must consider any information provided by the applicant before it makes a final decision within those 5 days. If the final decision is to then deny employment after those 5 days of giving the prospective employee time to provide evidence, the notice must specify the procedure for challenging the decision, as well as the right of the applicant to file a complaint with the California Fair Employment and Housing Department, which is called DFEH. So you can go ahead and file if the employee, a prospective employee, decides that, hey, well, you've given me the 5 days, I presented evidence, you're still denying me the conditional offer of employment. I don't think it's correct. I think it's prejudicial. I'm now going to file a complaint with the Fair Employment and Housing Department, the DFEH, within California. So that's the procedure now, pursuant to the ban of the box law, which is effective 1/1/18.
So Bill, what prompted the change in process?
Well, as I said, it really hones in on it does a couple things to ensure that there's no prejudicial reason for denying employment other than the conviction records itself, and secondarily to make sure that we're giving people a fair opportunity to be employed after they have paid their dues to society. Before, you could just say, hey, have you been convicted of a felony on the application before a conditional offer of employment? And if the employer saw that box checked, he could just deny employment without even offering a conditional offer. Now, you can't do that. You've got to be able to go through this process that I described earlier. So that's the reason for it. As I said earlier, Rick, there are certain records that can never be used against an employee, prospective employee, unless it's a conviction. And I'll give you some examples. Arrest records. Employees can't ask applicants any longer about prior arrests that did not lead to a conviction. So it must have been a conviction. If the applicant has been charged and is awaiting trial, that's not a conviction. So that doesn't come into play. The employer can't use that. Diversion programs. If an employee has taken a diversion program pursuant to a pretrial hearing, and he said, "Okay, I'll go undergo this diversion program rather than being convicted," the employer can't use that as a reason to deny employment. Sealed records, number 3. Employers cannot ask about convictions that have been sealed, expunged, or statutorily eradicated, where there's been a defective statute or where the records have been expunged pursuant to a rigorous process that the prospective employee has to go through to get the records expunged or negated. Number 4, certain marijuana offenses, and that comes into particular play because of the legality of marijuana in California now. But employers are prohibited from asking about non-felony convictions for marijuana possession that are no more than 2 years old. So you have non-felony convictions, can't ask about those. And then if there's a felony conviction that is more than 2 years old, you can't ask about that. But that only has to do with marijuana charges. And then number 5, juvenile records. You can't ask about applicants about juvenile records relating to arrest, detention, processing, or adjudication while the applicant was subject to the juvenile court system, because California does not consider juvenile decisions to be, quote, convictions that employers could otherwise inquire about. So that's important to recognize. And finally, I'd like to mention that federal and California employment laws prohibit employers from discriminating against applicants based on certain characteristics such as race and ethnicity, etc., medical condition, gender, sexual preference or orientation. So because arrest and incarceration rates are disproportionately higher for African Americans and Latinos, an employer that adopts a blanket policy of excluding all applicants with a criminal record could be charged with race discrimination. So that goes directly to the question you asked earlier. Number 1, this new law is in place to prevent discrimination. And number 2, it's in place to allow prior people who have gotten in trouble with the law to be given a fair opportunity to apply for a job after they'd paid their debt to society. So that's it in a nutshell, Rick. That's essentially the entirety of the new law, and it's a little complicated, but we have this show that you can watch and go over and really digest. And then, of course, any questions that need to be asked can always be referred to me by way of my direct contact number, which is 949-413-6535.
Right. Well, if you're an employer out there, then obviously take heed to this update. Would you share again the date that this goes effective?
Yes, January 1st, 2018. So it's been in effect for the past 9 months or so. I have been very busy and I would have liked to have gotten this out a little early, but better late than never. So I wanted to bring an update to our last show, which was in August, and I can't remember if it was 2016 or 2017, but that can be checked by going on our site and just pulling that up, and you'll be able to compare the old show with this new one and adjust your sites accordingly, especially if you're an employer, because you need to be aware of this stuff. You can't be accused of discrimination inappropriately. Now, remember that this applies to a California employer with 5 or more employees. It does not apply, everything we just said does not apply to a California employer who has less than 5 employees. So, we're bringing this update to you based on the presumption that you're applying for a job with someone who has 5 or more employees.
Now, why did they limit it just to that number and not just straight across the board?
Well, that's a good question. But the California legislature has determined that there are certain risks to smaller companies that can't be absorbed by smaller companies who don't have the revenue and the backing to be able to withstand going through a process of this rigor and being accused of discrimination. Because the employer would be could be threatened to be put out of business, or just doesn't have the financial wherewithal to be able to absorb these kinds of claims. Some might say that's fair, some might say it's unfair, but for whatever reason, in their wisdom, the California legislature has decided to say 5 or more employees.
Great. Well, if you're an employer out there and you have not been applying this update to your hiring process, and you have more questions, please reach out to Bill. His contact information is below. Thank you very much, Bill, for the update on that change to conditional offers of employment here in California. So,
and mention, Rick, if you would, because you have it down much more than I do, all of the places where we can be located if somebody does want to inquire of you or me.
Yes, you can always reach out to us on social media and on Facebook, Twitter, Google+. And like Bill mentioned, all of our archives of previous shows are located on our website, and that is bottledbusinesssenseshow.com. And so if you search for that episode that Bill had referred to, you'll find it in the archive as well. And they're all categorized in topics, so it's pretty easy to find.
And one point I wanted to mention too, Rick, is that Rick handles all of our great media sources, and so if by some chance we haven't gotten to the full update of all our various sites, and you see something referring to Blog Talk Radio or anything on our sites that where you may click a link and get a dead link and not get the appropriate information you're seeking, please notify Rick or myself at our email addresses. You can reach me at Bill at wfblegalconsulting.com. And Rick, where can they reach you?
You can reach me at rick@captivate365.com. So okay. Good. If you have a link to previous episodes on Blog Talk Radio, that will probably not be active in the coming weeks. However, you are welcome to click on the YouTube link, because audio-wise, the show's identical. One's a video presentation of what we do here. The other one's just strictly audio. but in all essence, the audio portion is identical.
That's a great point, Rick. So there you still have the option of viewing it and listening to it, or just simply listening to it by way of audio only.
Right.
Okay.
All right. Well, thank you very much, Bill, for the update. I appreciate that. And
you're welcome.
I hope our viewers out there learned from this. If you're an employer, obviously you want to take heed of this update. If you have any questions, please reach out to Bill. His contact information is below. So with that, Bill, thanks again. We will see everyone back here on the Bottle Business Sense Show in 2 weeks for the next episode. Have a great day, everyone.
Okay, take care, everybody.